Alrighty then, it appears that I'm live and in color, in living color. That was a program that was back in the 80s, I believe, for some of you guys that saw that program. Let's see, let me wait a few more seconds to get started. There it is, the clock just ticked away. Hello again, this is Daryl Williams with Win-Win Realtors right here in Southern California and from the YouTube channel Win-Win TV. Next time you're checking out YouTube, go and check out Win-Win Realtors TV, especially if you are dealing with estate real estate and going through a probate process, trust administration, or perhaps a conservatorship. Anyway, I'm going live today to answer 3 estate related questions. Estate meaning it's the estate real estate, I should say, related questions. It's the real estate related to the estate. Now, of course, as I always make an effort to do, is do like a reminder. An estate is everything you owned. And we're talking about someone that passed away and they left an estate, meaning things that they own. And I'm answering 3 really important questions, especially if you are the buyer. They would be helpful even if you are the seller. Okay, now I'm going to remind myself of my questions because I have him here in front of me, so you may see me look away and make sure I have the question correct. Is there a minimum price for which estate property must be sold? Is there a minimum price for which estate property must be sold? So now if you are a buyer and you're looking to buy property that's part of an estate, and usually your agent should tell you this is a probate estate property. Now the critical part about a probate property here in California when it's being sold is what kind of authority the personal representative has. Now, the personal representative is either the executor of the estate, meaning there was a will involved, or that person is called an administrator of that estate. And that means that was no will involved. Now, when a person's granted these authorities, they're going to be granted one of 2 authorities. One is called full authority, and it's critically important to understand this. One is called full authority, and if you think of something being full or complete, an authority, that basically gives you a clue on what's happening if you have full authority. And the other authority that's granted to a person is called limited authority. And that also tells you what's going on if you think about the meaning of the term limited. Okay, so now in answering this question, full authority or limited authority, or the question about is there a minimum price that you must put down, or or is there a minimum price that must be accepted? That's the first one we're dealing with. Is there a minimum price that must be accepted on an estate property? Okay. Now, I distinguish the full authority and the limited authority because if you have full authority, there's no limited price. The barrier is the heirs or the beneficiaries of that estate, meaning the persons that are going to benefit or the persons that are going to receive a form of inheritance from that estate. If you have full authority, basically, the personal representative, the person that's in charge, is going to use something called a notice of proposed action. It's a legal document that's sent to those parties, and basically it's asked for either their approval to move forward with this offer, or it asks for an objection. If there is an objection, you end up in court where the objection is heard by the judge. Okay. Now, the other is the full authority, and And again, as I mentioned, there is no particular amount that must be accepted. Now, if it's limited authority, everything is approved by the court and the rules of the court. And those court rules can vary from county to county. That's important to understand. So, the one that's really important for you to understand is the limited authority. So, yes, the offer on the property must be at least 90% of the appraisal value of that property. When a personal representative is given the authority over that estate and that property, one of the first things they do is take what's called an inventory and appraisal. And they determine that estate real estate is appraised and the value is determined. And that is even how it's decided what the list price of that property is going to be. That's important for you to understand. So the answer to that question of, is there a minimum price that you must pay for estate real property? Yes. If you're dealing with limited authority property, it is normally 90% of the appraised value, and the appraisal must have taken place within 1 year of the personal representative, the person that's in charge, receiving authority over that estate. Okay, so that answers that question for you. Now, the next question I have here, is there a minimum deposit required on estate real property? Is there a minimum deposit required on estate real property? So if you're planning on or you're looking into buying estate real estate property that's going through a probate administration, then yes, generally yes, the answer to that question. There is a minimum deposit you need to put down. However, it can vary from court system to court system, and it can actually be subject to the rules of that court. And again, it can vary from county to county. LA County, Riverside County, Orange counties, the rules can be differently. So generally you could put down 5% or maybe even 3%, but it's going to depend on the approval of the court. So that's my main point, if I confused it for you a bit earlier. Now, in general, here in LA County, they require 10% deposit. Now, when you make an offer with your agent, the agent's going to tell you to put up 10%, and it's going to be required because that is going to be required at the confirmation hearing. Now, there's going to be a confirmation hearing. A confirmation of what? Confirmation of the sale of that estate real property. So what happens, and this leads us to the third question, how soon must an offer be presented to the court for confirmation? The personal representative has 30 days to present that offer to the court for court confirmation and even the overbid process. You've heard of the overbidding process or the auction process. That's what's going to happen with a limited authority. The personal representative has 30 days to present that to the court. If the personal representative does not petition the court for confirmation of that sale, the buyer has the right to file a report with the court and petition for confirmation of the sale of that property. Okay, those are the three main questions I wanted to answer for you today. You know, there's a lot of information here. And as you know, I'm not an attorney. I'm a real estate broker. I work with attorneys who deal with estate real properties. So to review the questions again, is there a minimum price for which estate real property must be sold? Yes, if it's limited authority, as I mentioned to you, it must be within 90% of the appraisal value, and appraisal must have taken place within 1 year of the sale of that property, or in the 1 year of the personal representative receiving authority, receiving letters of administration or letters of testamentary. The other question was, is there a minimum deposit that estate real property that you must put down on estate real property? In general, the answer to that question is no. In general, it's based on the court's approval. Keep in mind, this is limited authority. It's all about the court approving. And why is it all about the court approving? The court is trying to maximize the dollar for the beneficiaries or the heirs of that estate. That's the court's obligation. Okay, so in general, it is 10% in most, in LA County. I can't speak for most counties, but if it's limited authority, it's 10%. And you'll have to bring on a cashier's check, money order, or some other form of cash, if you will. You will have to bring that to the court to the confirmation hearing. And that was the last question. How soon does an offer, meaning if you make an offer on an estate real property, keep in mind, you see people do this all the time with estate properties. They'll ask for a 30-day escrow. That's impossible if it's a limited authority, because it's going to take that long from the time that the executor or personal representative accepts your offer to then get that offer in front of the judge for confirmation of that sale. So you need something like a 60-day escrow anyway. So it takes them, the personal representative has 30 days to get your offer in front of the court. Or you as a buyer has the right to file that report with the court yourself, a petition for the confirmation. Alrighty, that's enough information for you. I'm Daryl Williams. Check me out over on YouTube at Win Win Realtors TV. And if you have any questions in general, look me up, reach out to me, share this video. Thanks for watching.